part of thanks for whoever did that. And so each LHRC member has received a copy of the petition. They've received a copy of all the exhibits, and they've been able to look at this and kind of study it before we ever get to this process. And that's an important piece of hearings, because you want your committees to be able to see, what they're being presented before the day of the hearing, because oftentimes the packets can be extensive. Sometimes we'll have a petition that's 2 pages. Sometimes we have a petition that's 30 pages with 70 pages of exhibits. Not what we want to happen, but sometimes it happens, depends on how that petition comes in. So without further ado, Artia is providing technical support to the LHRC committee today. At the end of the hearing, we are going to stay in this setting, and then you will observe how Artia provides technical support to the committee as they go through their deliberations. And then after that, we'll have a Q&A. So you can hold your questions until the end, and we'll go ahead and get started. Tia?
Yeah, thanks. So before we get started with that, I just want to let everyone know who's not part of the committee. As Cassie was saying, they all received a copy of the entire petition with the exhibits. They also received the fact-finding outline, which is on the shared drive. It's basically a script that the chair follows and reads word for word. And so typically when we're setting up for a hearing, I send that fact-finding outline to the chair and to the committee, and let the chair know right from the get-go, this is your script. Do not deviate from the script. Read it word for word. We also let the committee members know that the chair runs the hearing. So they are not to speak until the chair opens the floor. The chair is responsible for calling the meeting to order if anyone gets out of order. Also explaining to the committee in the body of the email prior to the hearing, I let them know that there is a time for questions in the script that they receive, and that's their time to ask questions. But when they do ask questions, I tell them, make sure your questions are as objective as possible. Try to avoid accusatory questions such as, well, why did you do that? Right? So we want to avoid those types of questions when we're making them. And again, this is all prep work prior to the hearing in an email that I sent to the committee. The other thing that I want to show you all, and I'll share my screen, is the mock LHRC findings and recommendations. Does everybody see that?
Yes,
yeah.
I can see that.
So typically the only person that sees this is the advocate that is assigned to the committee. And our role is basically just to kind of keep notes throughout the hearing. Again, this template is in the shared drive, so you can access it there. Everything that you see in red are parts that we kind of fill in. You'll notice here, please remember, do not identify the gender or initials of the petitioner anywhere in the findings. That is on the template. So before we release the findings, I will actually, well, let me do it, delete that, because these are then the findings that I'll save and I will send out once we are completed. So we have the petitioner there, we have the name. So all these in red are things that I filled in already, along with our statement of case. So as we're going through the hearing, I'll kind of just be scrolling down. And again, on that template, you'll see a lot of things highlighted that gives you, instead of typing out the entire thing, you can really copy and paste a lot of information directly from the petition. And this is all prep work. This is all things that I do prior to the hearing so that we're not typing as much during the hearing itself when we can really pay attention. So.
And I think I'll add on to that, Tia, before we get started, is that it's my understanding that a lot of this will be in the handbook that's going to be presented, correct?
Yes.
Okay.
Yeah, I believe that's accurate.
So we'll make sure you get all the resources that you need and that we're talking about today. They're already done for you. So we'll make sure that you get those.
Okay. So with that said, I am going to now turn it over to Brandon. he will be following the script. Now, we prepped this back in March 2020 for our all advocate meeting. So you'll notice the dates are a little off, but that's okay. So, all right, Brandon, I'm going to turn it over to you now.
Thank you. So welcome everyone to today's fact-finding hearing. Today's date is March 24th, 2020, Tuesday, and we are located at Region 10 Community Services Board. As a reminder, please place your cell phones on silent or turn them off. We will begin now. For the record, please state your name and position. What kind of order would we go in, Tia?
Yep, so start with your committee members first, and then you would go to the petitioner, and then to the provider, and then to the advocates that are involved in the hearing.
All right, so I am Brandon Rotenberry, the chairperson. Can the committee members introduce themselves, please?
Michael Gauss, committee member.
Carlton Henderson, committee member.
Mandy Crowder, committee member.
And we have Carrie Flowers also. It looks like she, I don't know if she can unmute that quickly, but she is also one of the committee members.
Oh, I didn't know anything about that.
Okay.
Okay, so we have, all right. And our petitioner, can you introduce yourself?
Hello, my name is Mrs. Mary Sample. I'm here representing my daughter, Susie.
Thank you. And from our provider?
Good morning. I'm Janet Jones, Senior Director of Group Home Residential.
Thank you. And anyone else we have here today, can you introduce yourself, please?
Sure, my name is Artia Ambrose with the Office of Human Rights. For the purpose of today's hearing, I am here to provide technical support to our committee.
And I am Cassie Pertleball. I'm the supervisor for Region 1, and I'm supervising today's hearing.
And I am LaQuetta Hayes. I will be providing technical support to Mrs. Sample.
Thank you.
I'm Maynard Ritchie, and I am attending as an observer.
Okay.
Okay, Brandon, go ahead.
All right. Each party to this hearing has several rights. I'm going to read those out to you. A reasonable notice of the hearing, a speedy and impartial review, appearance in person and or by a representative at the hearing, to be heard, to present facts and proof, including witnesses and documents, a prompt decision, an explanation of the basis of the decision, and you can appeal an adverse decision to the State Human Rights Committee. The client here has additional rights, the right to access information processed by the provider unless information is restricted from disclosure, an open hearing upon request, confidentiality, and freedom from retaliation. So with that said, Ms. Sample, you have the right to have an open hearing where all information discussed about you is available to the public, or your daughter is discussed with the public, and anyone can be present during the hearing. Or you can have a closed hearing where all matters confidential and only the people sitting around the table or are part of this hearing can be present. Would you like to have an open or closed hearing today?
So after talking to my advocate, I think we decided that I want to have this open because I really want a lot of people to hear about this travesty.
Okay, thank you. And you understand there may be confidential information disclosed?
I understand.
Okay. Thank you. So may it be noted for the record that the local Human Rights Committee is concerned with the preservation of client privacy and confidentiality of medical records. For this reason, we wish to assure at this time that the right to a closed hearing pursuant to the Code of Virginia 2.2-3711A15, paragraph 15, has been thoroughly reviewed with the complainant on behalf of the subject of the record, Ms. SS, is authorizing the disclosure of information that would be exempt from public dissemination. Okay. All right, so a little bit of explanation about the procedures of the hearing. Ms. Sample will present evidence and testimony first, followed by GHR, our provider. Each party will have up to 5 minutes for an opening statement, 10 minutes to present pertinent issues, and another 5 minutes for closing statements. The 5-minute presentation of issues may include witness testimony. In keeping with guidance from the State Human Rights Committee, the LHRC will not entertain cross-examination of witnesses by the other party. The LHRC may ask questions either of the parties and their respective witnesses. The LHRC will then go into executive closed session for deliberation and intend to deliver a summary of findings within 10 working days following this hearing, which is April 7th, 2020. Each party maintains the right to appeal an adverse decision to the State Human Rights Committee. A request for a fact-finding hearing was filed by LaQuetta Hayes, Senior Human Rights Advocate, on behalf of Ms. Sample. The petition being heard by the committee today alleges violation of the human rights regulations by not promoting best practice in accurate record keeping and neglecting Susie's personal hygiene needs. At this time, the committee will begin the hearing.
Brandon, if you don't mind, I'm going to step in.
Sure.
During your presentation time, as Brandon stated earlier, you will have 5 minutes for an opening statement, 10 minutes for a presentation, and then 5 minutes for a closing statement. When you reach your 1 minute time, when you have 1 minute left, I will hold up one finger to let you know that you have 1 minute left to present. Thank you, Brandon.
Thank you. All right. Ms. Sample, do you or your designee wish to use the allotted 5 minutes to make an opening statement?
Absolutely.
Okay. All right, your time will begin now, and as a reminder to watch RTF for your 1 minute warning.
No. So I entrusted my daughter, Susie, to the care of group home residential with the understanding that they were aware of her vulnerabilities and care needs. My expectation is that professionals will honor their stated commitments and communicate any difficulties they may encounter directly to the family of the person being served. Instead, I heard through informal reports from other staff, other professionals of other agencies, and other people that my Susie was showing up at school and Special Olympics events looking exhausted, disheveled, and unclean. This is not a professional service. This is not befitting of my daughter's needs or her rights. I'm here today on behalf of my daughter, as well as behalf of every other individual served by this agency. I need to see a change in these patterns, and I hope to see a change. Thank you.
Thank you, that was helpful. Ms.
Can I add the
Jones,
rest of
do
my
you?
time? Can I add the rest of that time to my presentation?
No, ma'am.
I'll have to
you may
ask our
not.
advocate.
No, ma'am. You have 10 minutes for your presentation.
Okay, thanks.
All right, thank you. Ms. Jones, do you or your designee wish to use the 5 minutes to make an opening statement?
Yes, we would.
All right, your time will begin now, and a reminder to please watch RTF for your 1 minute warning.
Thank you. Group Home Residential Services has been operating successfully for close to 2 decades. All clients are provided with a person-centered plan and a staff-to-person ratio that is appropriate for their needs and preferences. We have never received a citation for a dignity or services complaint in the past. We take pride in the success, presentation, and successful integration of all of the individuals we serve. We are operating in compliance with all regulations and have a 3-year triennial license with the department. Susie entered our, oh, wait a second, is that right? Susie entered our services on December 1st, 2019. I think I have that date wrong, I'm sorry. She's now in, she's new to formal services, and like many of our clients in the initial months of services, she is still very much adjusting to expectations to care for herself with a level of support that is adjusted specifically to her needs, but no more, in order to ensure her success and a therapeutic benefit. It is the policy of group home residential to encourage the greatest amount of independence possible for each individual we serve. We are not a beauty parlor or a retreat. We are providers of services for activities of daily living for adults with ID and DD. Our staff are well-trained in general methods of direct care support, the human rights regulations, medication, administration, and in the specific details of each person's individualized plan of care. Thank you.
Thank you. We are going to move on to our presentation of issues. Ms. Sample, you have 10 minutes to present evidence and witness testimony. Your time will begin now. And reminder to please watch for that 1-minute warning from Artia.
Thank you. During 12 years of care from me and my husband at home, 6 of which involved care with the CPAP machine, Susie has always been high energy and cooperative to work with. The reported patterns that have surfaced since she's been residing with group home residential are not characteristic, and more to the point, are concerning, and would seem to be more a reflection of the care and the attitude of the staff than of the person I know to be my Susie. I want to present Exhibit 13 as a reflection that my daughter's CPAP protocol was not being adhered to. This shows that they were not doing what they needed to do for my daughter's care.
Ms. Sample, I believe you got your exhibits confused. It's Exhibit 1.
Okay, right. There's just so much that these people did wrong. There's so many exhibits, I'm sorry. Okay, it's Exhibit 1.
No problem.
Okay, thank you. It's Exhibit 1, yes. A reflection that my daughter's CPAP protocol was not being adhered to. This shows that they were not doing what they needed to do for Susie's care. I would also like to present, I think it's Exhibit 2, the daily progress note. It's clear that they're not writing what's really happening because they mention that it's my daughter's birthday on 2 of the notes, even after her birthday. And they were the same exact notes. It's like they copied and pasted it. Look at the note for yourself. You can see it's the same note. 3 out of 4 notes are exactly the same within 1 week. I picked my daughter up every weekend. She's been placed at the group home. It has been a cold winter, and every time I pick her up, she's wearing a tank top. Oh, that's me. My voice coming back. Is that better? Can you guys hear me still? Is that going to take out of my time?
We can hear you. No, just keep going.
Okay. It has been a cold winter, and every time I pick her up, she's wearing a tank top. Did I already say that? One time she had on shorts. Another time she had on flip-flops, and it was 32 degrees and raining. She has wrinkled clothes and pants. Another time I didn't recognize the shirt, so I looked at the tag and it had somebody else's name on it. They don't take care of her hair. You can look at the pictures I provided in Exhibit 3. This is how I do her hair when she stays with me on the weekends. Exhibit 4 is what she looks like when I pick her up from their care. And you're right, it's not like a beauty salon. Their documents say they're doing her hair every morning and every night, but clearly this is not happening. Look at the pictures in Exhibit 4. They're not conditioning her hair and they're not taking care of it. I want my daughter to be presentable when she's out of the house or in front of her peers. This will affect her self-esteem. She's 12 years old and she wants to look good, but she needs help because it's a challenge for her. They need to help her. Thank you. And I hope you can help my daughter. And we would like to be paid for the extra treatment I have to get for her hair and my daughter's emotional pain.
Thank you. Do any of the committee members have questions?
So is this a time when we would just ask general questions?
Yes, this is when you would ask questions to Mrs. Sample.
Okay. Okay. I have one for the provider, so I'm good. Thank you.
Okay. Ms. Sample, I had one question for you, and I hope this question is okay, Artia, but when I was reviewing notes in your Exhibit 2, does your daughter like eating hot dogs and fries a lot?
What kind of question is that?
It's noted here several times, so I was curious about that
No.
in the notes.
No more than any 12-year-old likes to eat it. She doesn't like to eat it every day.
Okay. Yeah, I know that you said you felt like the notes were copied and pasted, and so I was looking at that as far as the diet. So thank you.
Okay, I get it. Thank you. That's a good question.
Thank you.
Ms. Sample,
Yes.
has your daughter complained to you about the services that she's receiving there? And I apologize if you stated that before.
Yes. Yes. She doesn't like coming home and her hair looks a mess. She doesn't like that.
Has she told you specifically whether or not the provider attempts to assist her with her hair?
Yeah, she said that I told them they have to do it, but she doesn't like it. The staff person doesn't like to do it.
Okay. Thank you.
I have a question, Mrs. Sample. Do you know
Are
whether or
y'all
not,
going to ask these questions to the provider too? I feel like you're asking me a lot.
if necessary?
Mrs. Sample, there will be a time for the committee to ask questions to the provider after they have made their presentation.
Okay.
So do you know whether or not 7:30 is her routine time to wake up?
No, she's 12. She doesn't like to do that.
Okay, so is she on some type of schedule while she's there, or?
She should be on a schedule. That was part of the program services that they promised me.
Okay.
I do have one question for Ms.
Okay.
Sample. Who provides the hair care products for your daughter?
I do. I've given them all the products they need.
Okay. Thank you.
I do have a follow-up question. You said that they don't like to do her hair. Is that something that they have said to you or said to your daughter?
That's what my daughter has told me. Doing her hair is a little complicated. It takes time. It's not like you just run a comb through it. And you need to have care when you do it. Sometimes it hurts. I mean, people have gotten their hair done right and you don't like it. It's uncomfortable. She's 12. So you're going to need to talk her through it and support her. She can tell that people don't want to take the time to do it. Was that a good answer, LaQuetta?
Yes.
Thank you. And I appreciate you answering our questions. It really helps us understand from your point of view what's going on here. So I appreciate that. My only other question from me was, has the provider ever asked you to help show them how to do your daughter's hair or how to work with her hair?
Listen,
I don't remember, LaQuetta. Have they asked me that?
I don't remember you telling me that they did.
Yeah, I don't think they did.
Okay, thank you.
I'd be happy to. I'd be happy to show them.
Okay, thank you. Any other questions?
I'm sorry.
Go ahead.
Yeah, I'm not going to keep us here all day, I promise. But I just want to be very thorough. The CPAP machine. Does Susie understand how to utilize and wear her CPAP
She does.
machine
She's
on her
been doing
own?
it for a long time.
Okay. Has she ever had any issues with wearing it after being asked?
Every
to
now
wear
and
it?
then, but she's 12. You tell her that she needs it, you explain it, you help her, she moves on. She's very cooperative.
Okay. Thank you so much, Ms.
That was actually a good question.
I try.
Okay, any other questions from our committee before we move on to the provider's presentation? All right, thank you. Ms. Jones, you will have 10 minutes to present evidence and witness testimony. As a reminder to look for Artia here, she will give you a 1-minute reminder if you get close. Yes.
Thank
All
you. With regards to the services complaint that the CPAP protocol was not implemented per the protocol, our documentation indicates otherwise. We have a protocol that we have implemented based on the information provided to us at admission that Susie sometimes removes the CPAP mask at night. The protocol states that her use and removal of the CPAP requires nightly tracking. A schedule of 30-minute checks was instituted and is consistent with our general GH policy for nighttime support staff. There are some gaps in the documentation which simply reflects the fact that redirection with the mask was not required at every check. Documentation reflects only the times when redirection was required, not merely checked. DSPs in our service do 30-minute checks as a matter of course. This is not something we document until specialized nighttime safety supports are required. With regards to the dignity complaint, the daily hygiene was not properly was not properly administered. Our documentation indicates that Susie was prompted and or supported to the level of her needs or willingness. Susie has had a pattern of not accepting staff support, and our staff are trained to respect the preferences of clients. We do not get into power struggles with folks around issues that are not relevant to safety. Our understanding of the human rights regulations is that each person has the right to dignity of risk. We expect that Susie may need to learn from experience that she's treated differently by some when she allows herself to receive support to look her best than she is when she doesn't allow herself to receive support to look her best. It's our philosophy that our best tool is our relationship with the person, and we do not want to undermine the relationship with power struggles. Instead, staff modify the amount and or quality of the attention they lend to behaviors that are less than ideal. Thank you.
Thank you. I have a question. I hear what you're saying about the documentation and the protocol. Did you submit any of that as exhibits for us to review? I don't have those.
I'm sorry, I did. You should have a CPAP record from January 2020.
Okay, I see that, but your protocol or your documentation that you're talking about where she wasn't cooperating?
That's outlined in her service plan. You should have a copy of it.
I don't have a copy of that. Did we get a copy
Jones,
of that?
You did not submit that as an exhibit.
Oh, well, we'll get it to you.
That's because they don't have it.
No, that's okay. Mrs. Jones, if you didn't present it as part of your response to the petition, you cannot submit exhibits later on.
Well, I'll just say that we developed the Part 5 residential plan like all providers do based on the information we were given at admission. And it's succinct, but it's there.
Okay. All right. Yeah, I do have your CPAP record that shows where, I have your CPAP record, but I don't see any documentation about why the CPAP wasn't used on certain nights. So that would have been helpful.
If it wasn't, if there's a gap, that represents that she didn't need the prompt. So we're not, we do the daily, we do the 30-minute checks as a matter of course. We're only noting when she's resistant and requires a prompt. Okay. So you'll notice there's not a lot of those there.
Okay, thank you. Other committee member questions now, please?
Yeah, I have some questions.
Thank you.
Please bear with me. So let's start with the CPAP record. So in looking at this, there are X's for the majority of the dates. So are you advising us that when there's an X, that's when Susie needed a prompt, or that's when she did not need a prompt? So the blank spaces is when Susie needed a prompt. And you also stated that your 30-minute checks are essentially par for the course, so you do not document in your daily progress notes that you all have completed the check.
I have a question.
So
I have a
how
question. Aren't you supposed to document everything you do?
Please, call to order.
Yeah.
Braden, go ahead.
Yeah.
Can somebody ask that question, please?
Ms. Sample, during this time, only the LHRC committee members will be asking questions. We would thank you for your patience while we participate.
I'm happy to address that. Our
Mrs.
staff.
Jones, that's not necessary. Thank you.
Okay.
So Mrs. Jones, if it's not documented, did it really happen?
It's summarized in the progress notes.
The progress notes that I have, they don't say that. Speaking of the progress notes, there are 3 or 5 dates that say exactly the same thing. So is it your practice to write the same thing each and every single day?
Yes, I'll answer that.
Activities of daily living are very routine. What we do is very routine. And so, yeah, our notes reflect that.
So it's not individualized.
It's individualized, but everybody needs support with their hair, everybody needs support with their teeth, and everybody needs support with breakfast. So yeah, it looks alike.
Mr. Henderson.
Not everybody has a birthday 2 days in a week.
Mr. Henderson and Ms. Crowder, as reminders, please make sure you are asking objective questions. Thank you.
Oh, please forgive me for not wanting to be objective when there appears that services are lacking. But I digress. I'll yield the remainder of my time.
And Ms. Jones, one question I had about the progress notes looking the same, it appears that Susie, at least in these sections, was eating hot dogs and fries every day. Is that routine for you all?
We try to cater to the preferences of our clients.
Is that her preference to eat hot dogs and fries every day?
She likes hot dogs and fries.
No, not every day.
Okay. Okay, Ms. Sample, just let us get through this, please. Okay.
Don't mute me again, I'll be quiet.
Okay, and just as a reminder, Ms. Sample, please refrain from putting LHRC business over in the chat box. We can't have it as a matter of record if you don't speak it. So if you could just not put it over there, that'd be great.
Okay, please don't mute me and I won't have to put it in the chat.
Okay. Right now we have time for questions from the LHRC member for the provider, Ms. Jones. Are there any other questions from our committee members at this time?
I have a question, Ms. Chair. Was the individual offered other meals other than the hot dogs and French fries?
We have alternatives anytime somebody doesn't like what's being offered on the menu.
No, that's not my question. The question was, did you offer her other things other than the hot dogs and French fries?
I'm sure the staff did. We have a freezer full of frozen meals for as an alternative.
Okay. All right, thank you. You answered my question.
Okay. Any other questions from the committee?
Yes, I have a question. Can you tell me how many staff members you have providing care for your individuals receiving services for your shifts and how those are outlined? So do you do 12-hour shifts? Are there 8-hour shifts? And how many staff do you have on each?
That can rotate depending on the needs of the particular individuals in any one home or at any particular point in time. Most of the time, we have a 1-to-4 staff to person ratio, which is within the licensing standards. But sometimes we have more than that. I can't remember from time to time, I oversee a lot of homes. I couldn't tell you exactly what the ratio was.
Is it not your practice to know what's going on across your program?
Like I said, it's very individualized, and we're working with a lot of people with special needs. And so I believe that the staff to person ratio for Susie was 1 to 4.
I have a question. On those progress notes, it mentions that she was excited about a birthday tomorrow. So how many birthdays does she have a week?
Like I said, the support is routine, and the staff are quite busy, and sometimes they're over redundant in what they say. So it is something we need to work on.
No further questions.
Thank you.
Ms. Sample, I really need to ask that you not use the chat box. Okay. We have rules for our hearings. We gotta follow the rules. And if we don't, then we're gonna have to, end your participation in the hearing. Okay. So I'm gonna ask that you follow the rules.
I got it.
Okay.
Sorry. Thank you. Thank you.
I know you're frustrated, but the committee's trying to help you, but we got to stay within the rules.
Okay. I'm sorry. Thank you.
Thank you. Are there any other questions for our provider here today? Ms. Jones from the LHRC. All right, we are going to move along then. Ms. Sample, now do you or your designee wish to use the allotted 5 minutes to make a closing statement?
Yes.
Great, okay. And please watch for that 1 minute warning during your time from Artia, but we'll hear from you now. Thank you.
Okay, thank you. The hardest thing in my life was entrusting my Susie into the care of someone other than me. I expect that they will take care of her in a way that is at least somewhat close to what I do for her. However, as you can see by the exhibits that I presented today, they are failing at even the simplest task of protecting her safety, her health, and her dignity. All I'm asking is that you be a voice for her. Help me help her and all the other residents at the group home who have birthdays 3 times a week by validating the concerns I presented before you today. Thank you for your time, and I trust you to help me do what's right by my Susie.
That was great, thank you. Ms. Jones,
I'd like to use another minute of my time for silence to acknowledge the pain that they've caused my family.
Okay, well, I believe she has that time. Can she use that, Artia?
No, it's a closing statement, not a closing moment of silence. So
Okay.
we will move forward.
Okay, thank you. I appreciate that. Ms. Jones, if you or your designee would now like to use an allotted 5 minutes for a closing statement.
Thank you. So in summary, group home residential does not accept the validity of the allegations made by Ms. Sample. And as you can see, sometimes family members are difficult and distort things. Instead, we would seek resolution through meeting the group home program manager, sitting down in order to learn more about our responsibilities with the department and the person per our policies. We would very much welcome the opportunity to get better acquainted, share our methods and thinking, and work together more collaboratively to ensure Susie's future success and comfort in her new home. We're open to revising how our documentation is done, as well as how we approach Susie with regards to hair care. But we would want to set up a meeting with Susie and staff in order to ensure meaningful participation by all. We also are not comfortable with providing a financial stipend in response to this complaint. Thank you.
Thank you. All right, the LHRC will now go into executive closed session for deliberation concerning the petitions heard today. The committee intends to deliver its findings to each party within 10 working days of this hearing, April 7th, 2020. Each party has the right to appeal an adverse decision to the State Human Rights Committee. At this time, all parties are dismissed so that the LHRC can deliberate privately.
Okay, so
Wait,
don't,
I'll turn
I have
this
one more
over.
question. I have one more question. Can I ask it?
No,
I'm
ma'am.
sorry,
The-
we finished.
so,
Thank you, though.
So taking a quick break in this script, normally this is the point where after the committee makes its motion that you guys, anybody who wasn't involved, that we would ask you to leave the room. And we would also let you know that when the committee comes back, that they're going to make a public vote on their findings and recommendations. They won't go into details, but they will give the, yeah, there was a violation of this, or no, there wasn't a violation of that. And so we would tell people that they could either wait in the waiting room, or the way that we do it in our region is I have the email addresses of the parties, and I give them a 5-minute heads up email saying the committee's going to be back in 5 minutes. So if you want to come back to the waiting room, then you can come in, you know, to hear the findings. So, so that's how we do that. We're asking you to stay because Tia is going to facilitate the deliberations with the committee, and it's an important part of the process and your role as advocates if you're assigned to provide technical support. And of course, obviously, we would not have anyone in here other than the LHRC members and our office. So at this point, I'll give it back to you, Brandon, to make your next statement there.
Okay, let me get to my next statement. All right, so I think we're in deliberation now. So we're in.
Well, you'll have to go into closed session. Yeah, so you'll read, you see that box, that part that's in red, the chair will say. Oh, nope, sorry, that's closed session. That's open.
I'm sorry, this isn't on my script.
Okay, that's okay. Go back to page, I want to say page 3, that statement for a closed hearing. So you'll have to read that statement.
Okay.
Yeah, Cassie, we will have to update the script. There are a few things that I noticed that aren't updated.
Okay.
Sorry, go ahead, Brandon.
All right. I move that the LHRC goes into executive session for an LHRC hearing pursuant to the Code of Virginia 2.2 3711A15 for the protection of the privacy of individuals and their records in personal matters not related to public business. Can I have a second, please?
Second.
Thank you. Any opposed? Okay, we are in executive session, so we can deliberate. Artia, I have a question first. It's hard for me to believe anything the provider said because they don't really have any documentation. So what do we do with that?
If it's not documented, it didn't happen. So if they didn't provide it, so typically, and this is for all the advocates, so typically when you are prepping the provider and the petitioner for the hearing, part of our job as an advocate is to assist them and tell them kind of the best way to present the materials. And so, for instance, with the petitioner, when we are assisting them in writing the petition, we will say, you want exhibits to reflect what you're stating. When you're making your statements, you want to say, you know, as Ms. Sample did, LaQuetta did a great job prepping her petitioner, you know, in here's my statement, here's my exhibit to back it up. Here's my statement, here's my exhibit to back it up. And so in her statement, she was bringing in her exhibits. We really, as advocates, should do the same with the provider and let them know in your response, make sure that you have documentation for anything that you're going to include in your response. And then we give them that same feedback of when you are presenting during the hearing, make sure that you are including your exhibits in your presentation. So make a statement as you can see in Exhibit A or in Exhibit B. So that's part of the prep that we as advocates do with both parties. And so by the time that it got here with Mrs. Jones, Lena, you did an excellent job, by the way, making up the answers. Great job.
So good. So good.
With Mrs. Jones, she just was kind of flying by the seat of pants. We can assume that the advocate prepped the provider ahead of time and said, hey, you should provide these documentations as well. And for whatever reason, the provider either was A, too lazy to do it, or B, the documents don't exist and she was just making up the whole thing. So that's where we are. Does that make sense, Brandon?
It does. Thank you.
Mr. Chair.
All right. So LHRC will, yes, go ahead.
I was going to ask you, what do we do now that we're in deliberations?
Yep. So I will, so I'm actually going to share my screen again and show you guys. Yeah. Show you again from our end what we do as advocates. So again, here's your fact finding, I'm sorry, your findings and recommendations. A lot of it was copied from the petition already. We get down here to this section on who presented. And so during the presentation, here I'm going to put petitioner. Again, we don't use names or initials or anything, any identifying information. So we'll put just petitioner there. And then here, Janet Jones, I believe executive director or something like that. Okay, and there were no witnesses, so we'll delete that out of there. Again, all of that was copied. So here we come down to our findings of fact. And so this is where we're going to say violation or no violation. So to the committee, again, typically I don't share this findings of fact with the committee. This is just something that's on my computer that we work through. But usually what I do is I direct the committee to go to their petition. I got to find which one of my documents that is.
And I'll just throw in here that she's actually, Tia's actually in her role right now, acting as the advocate, providing technical support. And she's asking her committee at this time to go ahead and pull your petitions because she's getting ready to take polls and that sort of thing to help you through that deliberation process.
Yeah, thank you, Cassie. So what we'll do for our committee, if you pull up your petition and on page 2, that's where we start. So for those of you that don't have a copy of the petition, oh gosh, you can't see it anyway. It doesn't matter. Never mind. White paper. It doesn't work. Okay. So what we're looking at is, let's start with 12 VAC 35-115-60B2 under services. This is the first allegation that's being made. And so what we'll do is I'll read it and then we'll do a quick poll of our committee and you'll just say, yes, I believe it's a violation, or no, I do not believe it's a violation. And once we do our quick poll of everyone on the committee, then we're going to discuss why or why not, why we feel it's a violation or why we don't feel that it's a violation. So the first one, like I said, 60B2, providers shall ensure that all services, including medical services and treatment, are at all times delivered in accordance with sound therapeutic practice. Providers may deny or limit an individual's access to services if sound therapeutic practice requires limiting the service to individuals of the same sex or similar age, disability, or legal status. The allegation here is that Mrs. Sample alleges that the provider was not acting within sound therapeutic practice. She states that the staff was not ensuring that the individual was using medically prescribed CPAP machine per protocol instituted upon admission on or about December 1st, 2019 through at least January 31st, 2020. So Brandon, if you want to do a quick poll of your committee, if they feel that it's a violation or no violation, and then we'll have an open discussion on the reason why they believe that way.
And I'll add to, typically, Brandon, we just go ahead and ask the committee to unmute themselves. That way you guys can freely talk with each other. So you can, you know, let your committee have conversation if they need to after the poll.
Okay, well, yes. So committee members, if you will unmute yourselves and let me know whether or not you think this is a violation based on what Artia just read.
I do not.
I do
You
not.
don't? Okay.
I do not.
Okay.
Can
What
you
about
clarify
everyone else?
that? Can you clarify, can she clarify that violation again, make it clear to understand?
Right. So the specific section of the regulations falls under 60B2, which is services. It says providers shall ensure that all services, including medical services and treatment, are at all times delivered in accordance with sound therapeutic practice. And then the allegation is that the provider was not acting within sound therapeutic practice. She states that the staff was not ensuring the individual was using her medically prescribed CPAP machine per her protocol instituted upon her admission.
Okay.
So what does sound therapeutic practice mean?
That's a great question. Let me answer that for you.
And while you're answering that, I mean, if we don't have a protocol to see, then how do we know whether or not they did or did not follow the protocol?
Well, see, I think it's a violation because the only document she referenced was that there's missing times that they didn't have accounted for the CPAP being used, and she has no documentation and no protocol. So I don't know how y'all would say there's no violation.
Yeah, I would say it's a violation.
Yeah. But we're saying it's a violation of sound therapeutic practice. So we have to really understand what is sound therapeutic practice.
Sound therapeutic practice would be that they follow all protocols to ensure the safety of that individual, the treatment. So if there's no documentation to show that they did follow all the protocols, then it's not sound therapeutic practice.
I like that, Carrie. I'm gonna go with Carrie and say that was a violation.
Okay, so we have 3 for violation. That means we win, right?
Yep, majority rules.
Okay.
Is that right, Artia? Does majority rule?
We already got it. 3 against 2, so we win.
So it is, but now you have to have a discussion on
why. So violation based on what?
Well, I mean,
she didn't have a policy.
Yeah.
There was no protocol. There was no documentation about what went on. The only thing we have is exhibit 1 that she even referenced herself that has missing times that the CPAP wasn't used with no explanation.
And
so
honestly,
I just can't believe what she said.
Yeah, I think they just need to be shut down. So because she just doesn't seem to know anything. They don't take responsibility. And I think that should be the recommendation, that they are shut down.
So I want to point out in your exhibits, if you take a look at exhibit 1 where it's talking about the protocol, remember Mrs. Jones' verbal testimony was that their protocol required half-hour checks. If you look at exhibit 1, they're only indicated every hour.
So Ms. Sample was right when she said all lies. Lies, all lies.
So the basic didn't follow their own policies.
Yeah, and can she, I mean, is it a fact if she just says it and has nothing to back it up?
She meaning Mrs. Jones?
Yes.
I think they call those alternative facts.
So once again, if it's not documented, if we don't have the documentation to prove it, it did not happen. So because
so I just don't believe her.
Because that wasn't presented to us, that's not something that we can make a decision on. So we have to make a decision based off of the documentation that was submitted.
So if there's no documentation, then there's no protocol, which means there's a violation.
Yeah.
That's what I see, violation.
Okay, so for those of you that are looking at my screen, again, the committee wouldn't see this, but as they're talking, that's where I start writing. So I would actually, because the committee is determining that there's a violation, I would go ahead and start prepping that on the basis of the following. Let's see. Committee determines, and then typically I write this in a way for me to kind of understand. And then once the hearing is over, I go back and I pretty it up and make it sound better. So, when it determines violation based on a lack of documentation or a CPAP monitoring protocol.
While you're writing that, Tia, I'm just gonna talk for a minute. One of the reasons Tia is doing this is because we've found that it overwhelms the chairperson to be responsible for typing everything in and getting it into the format that we want. So after Tia writes this in, we send this to the chairperson to review to make sure that it reflects exactly what they want it to reflect, right? Because it's their findings, it's the committee's findings, not our findings. So we just do this as a courtesy because it seems to help make the process flow better. You may have a committee chairperson who's very capable of doing this, him or herself. So, just that's why we do this. But these are not our findings. These are the committee's findings. So I just wanted to clarify that.
Right. And so to the committee, what I will say, so back into my role. Okay, committee. So what I have is that you have concluded by a vote of 4-1, I believe, that there is a violation concluded on the basis of the following. The committee determined violation based on a lack of documentation for a CPAP monitoring protocol for Susie. Is that accurate?
I believe it was 3-2.
3-2. Okay, those other two, do you still feel that there was no violation, or has the discussion changed your thought on it?
Discussion changed my
The
thoughts.
discussion has changed my thoughts.
Okay.
That's how we do it.
Okay.
Perfect. We love it.
So by unanimous vote then.
So where do we put that they are to be closed down?
Henderson, recommendations at the end. However, I will tell you that it is not within the purview of the Human Rights Committee to shut down a provider. So, but we will talk about that right at the end once we finish our conclusion. Okay. All right.
Okay, but I hope we can give her some money at least.
Yeah.
Also not within our purview, Mr. Chair, and you should know that.
Oh.
Why can't we give her money?
No monitoring.
If you want to pull $5 out of your pocket, go for it.
So are y'all looking forward to the Super Bowl on Sunday?
All right. Well, let's stay focused, Mr. Henderson. All right, moving on to 60B8, services, which states providers shall ensure that entries in an individual services record are at all times authentic, accurate, complete, timely, and pertinent. The allegation.
Violation.
Okay,
yeah,
so
just
we
go ahead
have
and
to
put
read the
violation.
allegation. All right.
Okay. Okay.
All right. So we're saying violation concluded on the basis of the following. Go ahead.
Well, they basically cut and pasted two progress notes. Well, two progress notes.
At least, and it looks like she's eating hot dogs and fries every day, and she's got a birthday every day. So.
Birthday. Yeah.
Yep.
Exactly.
And even though we didn't see the protocol, Ms. Jones said it out of her own mouth that they're supposed to do 30-minute checks. The protocol, the CPAP check is every hour. So she got her own self in trouble there.
Mm-hmm.
Yeah, I agree. Okay, so Exhibit 2 reflects individual 1 had a birthday, or I'm sorry, what appears to be a daily progress note, copied and pasted. Sample, individual 1 had, was it 3 birthdays in a week or 2 birthdays in a week?
3.
I believe it was
3 birthdays in
yeah.
a week. And 3.
Yeah, you might want to consider just writing that as there was the same documentation for 3 separate dates.
Okay. So again, I don't write it exact. I just write it enough to get and documentation. So again, I just write it to kind of get the committee's, this is teaching. I just write it to get the committee's thoughts, and then I go back and make it pretty later. So Mr. Henderson, you said something about Exhibit 1 with the protocol. Do you mind saying that again? I was typing for the other.
Sure. Although we did not see the protocol, Ms. Jones advised that checks were supposed to be done every 30 minutes, but the CPAP monitoring record is every hour. So she's a liar.
It's either that or very forgetful, one of the two. Okay.
Can we add in a violation for them not varying her diet? Because they're giving her hot dogs and fries every day.
Yeah, absolutely. So that would fall in the human rights regulations.
Yeah, except for, are we sure that they're giving her hot dogs every day, or was that just a copied and pasted entry? Which made
That's what she said.
She said that.
Yeah, she did state that they offered it to her every day.
And all she said was they offer alternatives of frozen foods if they don't like that, but she never would answer.
Yeah, she didn't answer the question. She just stated what they had in the freezer. She didn't say whether they offered her anything or not.
And Carrie tried to ask her that question several different ways.
I know, and then Carrie mumbled under her breath when she was done. We all heard it.
So I got cracked up, actually.
All right. So Mr. Rotenberry, that's going to fall under the Human Rights Regulations 12 Act 35-115-50C2, which says that in services provided in a residential and inpatient setting, each individual has the right to receive nutritionally adequate, varied, and appetizing meals that are prepared and served under sanitary conditions. So it certainly could be a violation of not offering a varied diet. But before we get to that, let's finish what is included on the petition. So what's included on the petition, we're going to jump to 50C1, dignity. So again, if you look at your petition, individuals have the right to have sufficient and suitable clothing for his exclusive use. The allegation here is that the daily hygiene was not properly supervised. The individual's hair was not kempt, and her dress was disheveled on most days. Mrs. Sample alleges that Susie was often dressed inappropriately for the weather conditions, which were witnessed on numerous occasions by the guardian and case manager. As a result of numerous complaints by and several meetings involved with the group home residential, the case manager, and the guardian regarding her appropriate care for the individual, a hair protocol was written and a verbal agreement was made to ensure the individual's hygiene was properly maintained and Susie was dressed appropriately. So violation or no violation?
Well, I feel like the pictures showed her hair wasn't properly cared for to support what Ms. Sample was saying, but also they're saying in these notes that they're completing the morning routine, but it's all copied and pasted, so how would you believe anything? Whether they're doing it or not. There's no protocol for us to review that they've done it. They never got any help from the mother to learn how to do her hair if they were having problems with it. So I feel like it's a violation.
Yeah. And what was done to address the inappropriate clothing?
Mm-hmm. Right. Yeah. So that was the only thing, Mr. Rotenberry, I was going to point out. I want to draw your attention to this specific regulation. Individuals have the right to have sufficient and suitable clothing for his exclusive use. So that's the specific regulation.
Yeah, so it doesn't say anything about looking pretty. I mean, I feel sorry for Miss Sample and her daughter, but is it a regulation that say they have to make them look pretty?
There is not a regulation that says you have to make them look pretty.
Okay.
No, but the clothing issue is an issue. It's a possible violation because I didn't hear anything where the provider ensured that she had appropriate clothing on. You wouldn't send a child out into the winter with shorts on and whatever. Flip-flops, yeah.
But I don't
what
feel,
about
regardless of the preference, you know, you don't send them out with inappropriate clothing on.
And
but I
didn't
don't
Miss
feel-
Sample say something about the tag showing it was somebody else's clothes?
Somebody else's clothes, yep.
I don't feel like we have evidence of that though. How do we know? The only evidence we have is that the hair was, according to Miss Sample, was disheveled. But what if the young lady liked her hair like that?
Oh, the hair issue. Now, you know, if she didn't, that wouldn't be particularly a violation if she just didn't get the hair fixed perfectly like she wanted it. She stated that the providers tried to help the individual comb her hair or do her hair, but she didn't really cooperate a lot. So whatever the hair issue, to me, is not really relevant. It's the clothing situation.
Yeah. And that's why I agree with you, Carrie. So I don't think there can be a violation because the only thing we really talked about was the hair, and that's all we see. And that's not clothing. So
yeah. Because was there any evidence that she was sent out with inappropriate clothing on? Was there an exhibit or anything?
No,
Nope.
we did not
No, just
receive
the
any
mom
evidence.
talking about it.
We
no,
did not receive any evidence, no.
No. So.
but I think we should
So-
go ahead and make it a violation though, because I feel for the mom and for the girl. So can we just say it's a violation?
So wait a minute, did the provider say that she went out with inappropriate clothing? Did she
No,
ever
she
state
did
that?
not. She did not.
Okay.
I wonder why they didn't have the case manager come in and testify that the case manager had seen that too.
Yeah, because she also mentioned, I think the mom also mentioned that there were other people who witnessed it, and we didn't get any of that evidence.
Right. Both parties were given the opportunity to present witnesses. Neither of them chose to do so.
See, I guess I just want to believe the mom because she's been able to support everything and the provider hasn't. But
Yeah. But I guess if we got to be fair, right? So
Right,
state the section of the regulation that we're questioning whether that provider violated.
Yep, so it is 50C1 states that individuals should have sufficient and suitable clothing for their exclusive use. And so the question that you have to ask yourself is, was there evidence that was presented that she did not have clothing for her, suitable clothing for her exclusive use?
nah, they
Okay,
didn't.
well, then that's a no violation.
Yeah.
And neither party presented any evidence.
yeah,
So
I have to say no violation too.
Can we find some other violations for them?
We're going to talk about that in a second. All
Okay.
right. So
We're going to add in that diet, hopefully.
So no violation concluded on the basis of the following. Documentation was not presented to determine.
Is it sound therapeutic practice if they're not taking care of her hair and sending her out like that?
Not particularly.
And without clothes?
Correct. We could certainly add that into your finding under 60B2. Let's see. This one documentation was determined.
So do y'all provide lunch for us doing these things?
We do not.
Oh.
So
we'll be finished by lunchtime. Don't
Yeah,
worry,
that would be
Mr.
nice,
Henderson.
wouldn't it?
It would be. I mean, we have to come and do all of this work.
I will tell you, Carlton, breaking character here, Cassie and I have done that in the past for our committees.
Of course. You all are Region 1. Why wouldn't you?
Well, it's because we had a 500-page petition. That's why. Literally 500 pages. Let's see. We felt bad for him.
At one time, the providers provided a buffet for LHRC members.
That'd be nice, wouldn't it?
Wow.
That's probably Brandon.
We do have food for our LHRCs, but we got to get back to in person. So.
Okay.
But yes, I have to brag on my facility. Dr. McClaskey always provides a really good lunch.
Yeah. Region 5 did too when I was in there. So.
I think my office location gives a really good lunch. My house, so nice.
We'll be there soon.
Bringing us back to our petition here, I just wanted to add that Tia is adding a violation here that was not originally presented in the petition. This is not something that happens every time. It's happens less often than it happens. So we just need to be really aware that we don't typically add a ton of, violations to something that's not being presented. So we have to be cautious in adding things that weren't presented. That's something that we've kind of evolved. It's hard if the committee has recognized something, that's pretty black and white or crystal clear, we add it, but we are careful with just tagging on a bunch of violations because that can cause us issues.
Yeah, absolutely. I would say the only time we really ever do it is if it's something that's pretty egregious. And as you could hear in Mrs. Jones' statements, a lot of their actions were very egregious. So, all right. So back into character. Mr. Rotenberry, you had stated previously about wanting to issue a citation specific to offering the hot dogs and French fries. Would you like to move forward with doing a finding specific to that regulation that I read earlier, that individuals have the right to receive nutritionally adequate, varied, and appetizing meals?
Personally, yes, I would. I don't see that they're giving her any other options or anything else that would provide her any good nutrition. So I'm worried about that.
Yeah, because
Okay.
she's not getting any nutrition.
Right. In a poll to the committee, how do you all feel about adding that?
So I'm kind of on the fence.
I think you should add it.
Yeah, I'm not so sure because suppose the individual, that's all she's asking for. There's no evidence of either.
Well, no, the provider didn't state that's all she was asking for. The provider made it clear that she didn't make it clear, but she didn't offer anything else but the hot dogs and French fries. The individual don't know what's in the freezer or anywhere else.
Mm-hmm.
And I think that's what still makes me be on the fence. Like, maybe we didn't ask enough questions. The evidence wasn't presented,
But also, if you look at the fact that all she's giving her is hot dogs and French fries, that's not therapeutic practice. That individual is getting a very unvaried and unhealthy diet.
well, hot dog is protein. French fries is a vegetable and a carbohydrate.
No, that's
No.
poison.
That's a starch. I don't see any plan. Yeah, they're not addressing her nutritional needs here.
Well, I'll go with whatever y'all say.
Michael,
Okay, well, we'll put you down for
quiet.
violation.
What do you think?
It can go either way. I thought the provider did say that that's what she was explicitly asking for, but at the same time, we agree that we don't know whether or not she knew of anything else even being in the fridge. So I'm either way with it. I can go for it or not.
Okay. So it doesn't
Can we
sound like
Put him down
redirect
for
her?
violation.
well, it doesn't sound like we have a majority that feel strongly that it's a violation.
Well, we can put Michael down for violation. We can put Carlton down for violation. Me and Carrie.
Nope, it doesn't work that way. Sorry.
I'll
They
change my
don't.
vote then. I'll go for violation.
And I'll go
Okay.
against the violation then.
Okay, so violation based on what? Based on the following.
The only
Carrie said it's
documented
poison.
meal, the only documented meal was hot dogs and fries. There's no evidence that they offered anything else to the individual. And the testimony from the provider was that was their dinner.
Yeah.
And the mother specifically said she likes hot dogs and fries, but that's not all she will eat.
So I'm just going to add while Tia's typing here. This is a time where, despite the advocate's technical support to the committee, that, it did not look like she had a unanimous number of, or not unanimous, but a majority of people who wanted to do this. The committee flipped and they're pretty much insisting on doing this violation of 50C2. It is their findings. And so that's why we have the SHRC process, the appeal process, is to review whether or not the findings are correct, that the process was handled correctly. So we'll go ahead and add it on here at the insistence of the committee. It is something within their purview to do. So that's why Tia is allowing it to move forward. But just wanted to point that out, that sometimes despite your best effort to redirect a committee, they have their own findings. And so we honor that and put it in the findings as long as it's within our purview.
So I have a question. Are we focusing exclusively on the hot dogs and fries, or Cheerios and toast okay too?
It didn't sound like she got anything but hot dogs and fries.
With the same breakfast?
Oh yeah, you're right.
Or two.
Yeah. Now again, I have to say that's whole grain.
There's no fruits, there's no vegetables. But I mean, I think that's a good point. I mean, they're saying that she's eating that every day as well.
Well, some people just like cereal.
Did she say she got cereal?
It says for breakfast, Cheerios and toast every day.
But who knows if that's accurate or not? That could have been for somebody else.
Mm-hmm.
That's
I
true.
know. I just feel like
That is very true.
I just feel like they're trying to give them real, like cheap food. There's nothing they're preparing or feeding them. So I'm just worried that they're not getting anything but the basics.
Well, Cheerios are not that cheap. They're rather expensive, $4 a box.
You can get the generic.
Who wants generic though? Doesn't even taste the same.
All right.
Well, it doesn't sound like she has any
I'll
options.
just pile some sugar on it.
Oh, wow.
All right, so I just want to review our findings. So you have determined a violation of 60B2 by unanimous vote, a violation of 60B8 by unanimous vote, no violation of 50C1 by unanimous vote, and violation of 50C2. Is that by unanimous vote as well?
Yes.
Yes.
Yeah.
Oh, Michael. I don't know if Michael was going with us.
I'm outvoted.
Okay, so you disagree,
He said we could
Michael?
put him down for violation.
I can go for violation. Go for it.
Okay.
All right, so give me one moment. I'm doing our findings here. Okay. And all by unanimous vote. So as you can see, back to teaching, we do have by a vote of 0-0 or unanimous vote. If there is a split vote, there is a way for me to say by a vote of 3-1 or 4-2 or whatever it is. So it does not have to be a unanimous vote by the committee. Okay. All right, so back to my roll. All right, committee, if you could take a look at your petition once again. Now we're going to move forward with making our recommendations. So you're going to see that on page 3 of your petition, and then it goes to page 4. Okay, so these were all requested by Mrs. Sample as part of our recommendations. Some of them are within our purview, some of them are not. So we will discuss those. So the first requested resolution we have, GHR will provide a copy of the CPAP protocol for the individual. That is within our purview. That is something that we can recommend.
Yeah, I think they should have that.
Will the mother get a copy too?
Yes, so when it says individual, that's who it's referencing. What is happening? All right. All right, the next one, GHR will develop and implement policy, procedures, and protocols requiring that all staff members are trained and certified on the operation and use of all medical equipment to include, but not limited to, a CPAP machine.
Yes, absolutely.
Well, hold on. When you say all medical equipment, I mean, all medical equipment, like in the hospital?
That's used in that home.
Well, if they're using it, they need to know how to use it.
Yeah.
Mm-hmm.
I feel like that's just really broad.
No, for all
Right,
medical
so would
equipment.
you like to reword that then?
Like something like all medical equipment necessary for the services of the individual served in that home or something like that.
Yeah.
That sounds good.
Okay. All right, the next, all medical equipment operating during sleeping hours will require overnight staff to check in via phone to a designated independent third party. A live person every hour with the status of the resident and verification that the medical equipment is in operation and performing correctly and the resident is safe. Now, this is not within our purview as a committee to direct how providers run their service. So that is not within our purview.
Okay.
All right, GHR will update their software to ensure that all medical equipment, such as a CPAP machine, are being used and properly documented electronically. Again, not within our purview to designate specific software for providers to use. All right, the next one, GHR will provide a copy of the hair care protocol for individual one and the policy for ensuring that the protocol is being adhered to by staff.
Back to D really quick. Are we able to still add that the house manager will be required to perform unannounced spot checks?
Oh yeah, that's good.
So we can't require the house manager to do it. What we can say is we recommend that they develop a protocol for evaluating that machines are being, properly implemented.
And the documentation.
Mm-hmm.
Okay, that would be good. Let's see. Gotta go back to this.
Okay, so let's move on to the next one, what we just read before. The GHR will provide a copy of the hair care protocol for the individual and the policy for ensuring the protocol is being adhered to by staff. That's certainly within our purview to recommend.
So we can do that even if we didn't find a violation for it?
Correct. So basically, she's requesting a copy of her child's treatment record. She wants a copy of the policy that's affecting her child's treatment. So absolutely.
Okay. Yeah, I like that one then.
Okay. Okay, GHR will develop and implement policy, procedures, and protocols requiring GHR staff to be trained and able to care for all residents' hygiene needs regardless of race or disability. The house manager will ensure that it is adhered to and visually verify as required and documented electronically using properly configured software. So again, that last sentence, not really within our purview to tell them how to do it, but certainly we can recommend that they develop and implement a policy for resident hygiene. Is that something you all would like to keep?
Yeah, don't the regulations
Yes.
already state that there has to be policies against discrimination?
Right, so part of your findings and recommendations is once you make these recommendations, it gets sent back to the provider, and then the provider has to develop an action plan of implementing your recommendations. And so this will make sure that the provider is specifically addressing these needs.
Okay. But we're going to get them closed down, right? So does all of this stuff matter?
It's not within our purview to close down a provider.
Oh, who can do that?
Well,
Nobody.
that's a process. The big answer is the commissioner. Not
is there
us.
any way we
That's
can add in there somewhere to consult or include the mom in developing the hair care protocol, or some training from her, because she seems to know how to do her hair and how to work with her.
Well, this client's been discharged.
Oh.
Okay. Well, just in general, I guess the policies will be good then.
Yeah. Okay.
But yeah,
All
because
right.
the mom did say she wants to make sure all the other individuals are taken care of. So I think that's good.
Yeah. Okay. All right. Next one, GHR will develop and implement policy, procedures, and protocols requiring all staff to check each resident prior to them leaving the residential home to ensure that they are appropriately dressed and groomed and documented electronically using the proper configured software. What do you all think about that one?
Yeah, I guess so, except for the last part. Mom is really on this electronic software, huh?
Okay, we might want to add in here in line with their specific treatment needs and preferences. All right, are you all okay with that?
Yeah.
Yes.
Okay. All right, and the last one, group home residential should provide financial compensation for emotional pain and necessary hair treatment. Again, it is not within our purview for financial compensation. If that's something she desires, she will have to go through another route. Okay. Any other recommendations you all would like to make?
I think we need to add something in about fixing their documentation where they're copying and pasting notes and not really reporting on what's going on that day. And then also something about addressing the meals in the home.
Okay.
So I will just add that as part of the corrective action to the violations, we will have to, in OHR, ensure that the evidence of corrective action has been implemented. So obviously you guys have a violation, I believe, up there specific to documentation, right? So, they would have to provide evidence of that. as well as with the other violations. So.
Okay.
Mhm. Okay. All right, so GHR will assure individuals receiving services are offered a nutritionally adequate and varied diet. And what was the other one you said?
It was just, I don't know how to word it, but something about where they're copying and pasting their notes and not really accurately reporting.
Is it almost over?
It is almost over. Yeah.
Oh.
I told you I'm going to get you out of here before lunch.
Mhm.
And, okay. All right. Any other recommendations?
I'm sleepy.
Again,
I'm good.
and again, going back to a teaching moment, this is not how I send the recommendations back to the committee to review. I just kind of take notes as people are talking, and then I pretty it up when it's all said and done. So
We actually do have samples available of findings and recommendations that, you know, have been done accurately, and those will be provided to you guys as well.
So then there's a statement, the LHRC considered all of the requested resolutions of the petitioner, but believes the above recommendations to be in line with these findings and the regulatory purview of this committee. All right, so now we need to go back into open session. And you're going to find that language on your script. I'm going to find, this is exactly how a hearing is. I'm flipping through all my paperwork. All right.
And I'm the chairperson looking for what to say.
I'll tell you as soon as I find the script. It should be on the last page.
Yeah, it's in that box.
At the bottom, yep, the bottom of your last page in the box, it says the chair will say.
If I can interrupt for just a second, Tia and Brandon, before you go back into open, yep. Tia, you may want to ask your chairperson if he's comfortable with you verbally stating the findings. Wouldn't be able to see it normally.
I was getting there. Thank you. Yep, thank you. All right, so what you're going to do, Brandon, is you're going to read that statement that says, upon reconvening into open session, blah, 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 blah. At the end of that statement, you're going to request that all members of the committee say "I so certify," which they will then do in a roll call fashion. So Brandon, if you could say Carlton, and then Carlton will say "I so certify," Carrie, and then Carrie will do so, and then do that way.
I have a question.
Also,
since we made a motion to go into closed session, wouldn't we have to make a motion to go out?
Yeah.
Yeah, is it?
Yeah.
It should be on the template.
Yep.
Okay.
Is it not on the old one, Tia?
It is not on the old one. That's one of the updates.
That's one of those updates. Tia, do you
Don't get me wrong. I know you've worked hard on this. I'm just questioning from my understanding.
Yeah, nope, you're
too.
good.
Okay.
You're good. Yep. Yeah, we'll add that to the new script.
Okay.
All right. So once you come back into open session, Mr. Chair, is it okay with you if I go ahead and read your findings as stated? So what your findings are is by unanimous vote, the LHRC recommends violation of the following: 12 VAC 35-115-60B2 services, 12 VAC 35-115-60B8 services, 12 VAC 35-115-50C2 dignity. And then by unanimous vote, the LHRC recommends no violation of the following: 12 VAC 35-115-50C1 dignity.
Okay.
And then Brandon, after that, you're going to call for a vote on those findings. okay, in public session. Tia, since he doesn't have that statement, you might need to read it on behalf of the committee so that we come out of that executive session. The statement of bringing us out, a motion to come out. Do you have the ISO certified statement, Brandon?
I do have the
He has
ISO
that
certified.
statement.
All right,
Yeah.
perfect.
Okay, all right. So,
You
for
ready?
the purpose of this, yeah, I'm ready. Do you want me just to say it?
Yeah, go ahead.
Okay, so I make a motion that we return to open session. Can I have a second?
Second.
Thank you. Any opposed? Okay, we will go back into open session now. Do we have everybody back, Artia?
Yes, everyone has re-entered the room.
Okay. Upon reconvening into open session, the local Human Rights Committee certifies that only public business matters lawfully exempted from statutory open meeting requirements and only public business matters identified in the motion to convene the closed session were discussed in closed session. So I will need each LHRC member to say I so certify. So I so certify. Carlton, if you could say. You're on mute.
I so certify.
Okay. Carrie,
So certified.
Mandy,
So certify.
Michael.
ISO certified.
Did I miss anybody? I don't have the list in front of me. Sorry. That's us. Okay. We are good. All right. So now we're going to have a vote based on the recommendations made. So Artia, are you able to read those for us?
Yes.
Okay.
So by unanimous vote, the LHRC recommends violation of the following: 12 Act 35-115-60B2 services, 12 Act 35-115-60B8 services, 12 Act 35-115-50C2 dignity. By unanimous vote, the LHRC recommends no violation of the following as alleged in this complaint: 12 Act 35-115-50C1 dignity.
Look, Quetta, does that mean we won?
All right.
That means that you-
Brennan, at this time, we want to thank everyone for their participation.
And we would also remind them that the findings would come out in the 10 days in writing with the explanation and the recommendations, Tia.
Yes, thank you.
And Ms.
Okay,
Sample,
thank
I'll
you,
be in
everyone, for
contact with you.
participating.
Go ahead,
Thank
Brandon.
you. Anything else? No, I was just thanking everyone for their participation, and I imagine we would be able to adjourn now. Is that right, Artia?
Yes, correct.
All right. All right, we are adjourned.
Okay, so that concludes the mock hearing training part of the training. We'll open the floor for questions or comments. I don't know, Tanika or Jennifer, if you guys have anything to add.
Comments.
Okay.
I think that was so well done. Like, that, first of all, that was really fun, and I cracked my own self up. But like, it was kind of hard to be mad at you, Lena, because you were like doing a really good job with those ridiculous answers. I loved it. And I really like how I think committee members, obviously you all are experts at our regulations, but I think you all did a good job of showing how like some people just go off the deep end and how some people empathize with a particular type of individual or a provider. Like this whole thing was like really well done. And I don't know that as an advocate, like I've done this before, but I think this is the kind of training that I would have liked to have had myself to like see what it really looks like in a safe space. Because if you witness a real one, like you can't laugh, you can't like do stuff like that. So you got to be like all super professional. So this was a really nice environment to do it in. And I just can't thank you guys enough. Cassie, Tia, Lena, I know you did work on it. Like this was really thorough. Like you had exhibits and all. This was great. Like I'm so super proud of everybody in this moment. It was wonderful. Wonderful.
It was fun.
It was really good. Anybody else want to give people kudos? That was so good.
I just want to comment, y'all were the most out of order committee I've ever dealt with. All of you. Like usually you have one. No, it's all of you. Goodness.
Now, I really wanted to say, I think Artia did so well handling everybody and getting people back on track.
Me too, with that moment
just the amount of,
oh, that was so
Yeah.
crazy, wasn't it? Tia, I'm with you, Brandon. I would have been like, okay, yeah, sure.
She's
Yeah.
a great I don't waste time.
But the amount of work that went into this, I really appreciate that. And just, it was so fun to do this. And I did learn stuff along the way, but I really actually enjoyed a training, which is rare. So thank you.
Yeah, for me,
And
this
Tanika,
was
you're a good
great
actor.
because I've not gone to any LHRC hearings. I've been to the SHRC. So this was really helpful for me. And fun because y'all were cracking me up. So I just think everybody did an awesome job though. I mean, and my question was, after I choked, is there an RT at all the meetings like this?
Okay.
Yeah, I know what your question is, Mary Claire. I'll take you. I got your back over here, but hold your arms up like Carlton said, get that thing going. So yeah,
yeah, I don't know what it's doing, but
for in Region 1, we typically, because we have so many hearings and just the flow of things, Tia typically provide or always provides the technical support to the committee. She's very good at it. It's her strength. It works for our region. That might not be how other regions do it, but it works here. And so, you know, that is how we do it here in Region 1. I don't know if everyone else will, but she's so good at it. She's so good at the deliberation process, which she's learned by herself. She's had to train herself with that really, because you learn kind of as you go. We've been blessed in Region 1 with a lot of opportunities for training with hearings because we have so many. But yeah, that is how we do that for the technical support. And I will say that as fun as this was, it was so indicative of exactly what happens in a hearing. Like from the get-go with having some technical issues on Zoom to the interruptions by one party or the other. I mean, Tanika was a little bit extreme with going for the chat box. I was getting ready to throw her out.
That was well done, wasn't it? That was well done.
Well done. And then hold up, the 1 minute. But, you know, we do have those interruptions. We have that desire for people to want to, you know, cross-examine, you know, and the whole goal of this process is, you know, that we have something that is well-managed, calm, respectful, and that we get to the end of it for that complaint resolution. So as fun as it was, it really is how it happens. And we do have providers to blow it off and come unprepared or ill-prepared, I should say. And then they learn that it's kind of formal.
well, I just want to say y'all did great, and it really, truly helped me. I mean, I did learn a lot from how this works. So remember my superhero I wanted to clone? We need to clone people.
Thanks, Mary Claire. Are there any questions about the process?
I do have one question. I have one question. I don't know if you all have developed protocols or ways of doing it when a provider or someone brings their own attorney in where they don't have the advocate represent them, they have their attorney represent them. Yeah. And it throws a real boomerang in the show.
We do. We really honestly treat that the same way. We've had that happen in Region 1. Any petitioner can ask someone else to represent them. So, we expect them to follow the same rules that we would expect if an AR was presenting on behalf of the individual. So we let them know up front, this is not a legal process. It's not going to be like being in court. You can't object, you can't do these things. So we just make sure that it's non-adversarial in the very beginning, and we lay those rules out. Part of the other thing for this process is we do have emails, a template that we send out to providers and the petitioner before the hearing ever starts that says, this is the expectation, this is what you can do, this is what you can't do. So we treat it the same regardless of who's representing the individual or whether the individual is representing him or herself.
It can definitely change the dynamic. So I know what you're talking about, Carrie, but I think that's when the email template sent ahead of time, the conversation ahead of time, and then having a strong relationship between the chair and the advocate that's providing technical assistance to the chair to be able to nudge them when they need to say, okay, thank you. Okay, this is not appropriate. Okay, sit down.
Yeah, so someone won't sit down.
True, you're going to have a Miss Sample. You're going to have somebody out there.
That's right.
I think it's also good to talk about how advocates should handle a situation if someone brings a recorder or tries to record the hearing.
Yeah, so we've had that happen before, and basically you can't stop someone from recording a hearing. They're allowed to do that. Typically it's going to be the individual who may do that, and it's their hearing. If they choose for it to be closed and then they disseminate that information, that's on them, really. So it's not out of the realm of possibilities that it's going to happen. And we often, I can think of numerous hearings where the petitioner has said, I'm putting it, and they put their phone up and push record, and there it is. And we just keep on rolling with the same process that we have and follow the template.
Yeah, and we had a petitioner.
Don't like to record it. I'm sorry, Tia, I don't mean to speak over you.
No, go ahead.
As an office, we don't like to do that because that puts a burden on us to have to replicate it, to have to provide it to other people, all of that good stuff. But Virginia is a one consent state, so either entity could do it. We certainly can discourage more strongly the provider from doing it. But Cassie's right, it happens.
And I will add, in the Zoom process of hearings, we don't record it on Zoom either. We were doing that originally because we thought we had to, but we stopped doing that when we found out that we didn't need to do it. Sorry, Shrey.
Can a provider refuse to speak if a petitioner decides that they want to record the hearing? Has that happened?
Anybody can refuse to speak. They basically declined their opportunity to do their presentation and opening and closing statements, but it's not to their benefit to refuse to speak because they're here in a non-adversarial way to tell their story, what happened and how they were assuring those rights. So if they decline to speak, then the committee's going to have to go on the evidence in the petition that was presented for them. Jen Anglin, I think you had a question.
Yeah, I just had a couple procedural questions. I didn't realize that findings were actually delivered after the deliberations. Is that just because it was via Zoom, or is that normal protocol?
No, it's normal protocol that, because you can't vote on those things when you're in an executive closed session, all of that's foiable. So you come out of that session and then you do that open vote on the findings, there in open session. So you don't go into detail because the details may change, in that written report, but you do come back in and you provide those findings at the end of the hearing. So it'll also keep the provider off your back. It'll keep
I know that you. Okay, the part that I didn't realize was the individual and the petitioner is there for those findings. I realized you go back into open session, but I didn't realize they're actually delivered to them right then and there.
They can be if they choose to stay. They don't have to stick around. But I will say that is public information. So if the provider doesn't come back in, but they call you later that day and say, what were the findings? You can give them exactly what was said in the public session, but no more. You say, and you'll get the written findings and recommendations later, but it was a violation of this and it wasn't a violation of that. And that's the end of the discussion at that point. Same thing for the individual. If they can't stay around, for a 2-hour deliberation or whatever you have, and they want to know, then the assigned advocate can call them later on and say, here were the violations or non-violations.
Okay. Gotcha. All right, that makes sense. And then another question, at the beginning when you took polls, because we're on Zoom, you don't have to do the actual poll. You can just do like a verbal poll.
Oh,
you know those polls that you can actually make?
In deliberations, Jen? So that's when
I think at the beginning when you said, let's take a poll or something.
Yep, that was in deliberations. And the reason that we do that is to really get a feel for where the committee is. Because there's no reason to spend an hour talking about the first, potential violation. If all 5 members say it's a violation, we can go, oh, good, it's a violation. And now let's talk about why. So the polling.
And I will tell you, doing that is going to save you a ton of time.
Yeah.
We have learned that from experience doing that poll first.
Yeah, I get it. What I'm asking about is those actual polls that you can make, like the drop-down poll where people click on yes or no.
Nah, you don't have to do that. If you're like a Zoom expert and you want to do that and be fancy, you can, but we're not fancy like that.
No. Not at all. I was just making sure. And then one last question. So if you have a non-unanimous vote, like 2-1, the dissenting person, do you have to document in your documentation why they're dissenting and say who it was, and they have to give documentation on why they're dissenting?
No, you just put, now Tanika, correct me if I'm wrong, but we oftentimes have, votes that are not unanimous. And so we just put by a vote of 5-2, the committee voted, a violation of this for this reason. We don't ever put which committee members voted yay or nay to protect the confidentiality of those committee members, because what's done in closed session stays in closed session. So that's how we manage that. We would never put the name or the reason that they said no, because it would to me, it would undermine the process of why there was a violation or there wasn't a violation. Because
I just want to add to that. Yes, I agree with what you said. We would never out the people and be like, well, Carlton said he didn't agree. But I have seen where there is a statement about why the dissenting votes dissented. And I do personally think that is helpful, because if it were to get to the State Human Rights Committee level, they're going to want to know that. And it doesn't have to be a lot. So typically it'll be, because of this evidence, and this evidence is why they determined a violation. The 2 dissenting votes didn't agree that this meant that, right? So just another sentence.
Okay, good. We'll add that to
what I know you shouldn't reveal names, but that's what I was asking about. No names, but I didn't know if you had to add that additional documentation. Okay.
Yeah, when I'm doing it, I typically write, by a vote to 4-1, no violation. And then I'll say 1 committee member determined violation based on blah, 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 whatever it was that they felt. So
Tia's already.
It literally is just like 1 sentence though. What was that, Tanika?
I was saying that you're already doing it. Those are the ones I've probably seen.
Yeah.
She's always 1 step ahead of me. She's so good.
And then I got one last question. Sorry, I don't mean to monopolize. So can you make recommendations at the end for something that's not in direct relation to one of the violations?
So you want to stick to what is being presented on the petition. If your recommendation is grounded in the regulations and it's specific to one of the violations or the non-violations, then I think that it's fair game to put in the recommendations. But if it's not directly connected to what you're reviewing as part of the petition, then it shouldn't go there. You'll also notice when you get your packet of, your handbook or whatever, at the bottom of the template, you will see a statement that's really important that says the LHRC looked at everything you wanted, but this is what we decided was appropriate. That prevents appeals where the individual says, well, yeah, they gave these recommendations, but they didn't take into consideration this. And that's happened. And that's why that statement's there, because we did it. So, learn from our mistakes over here, or our growing pains over here, is that statement's really important. And it basically says, we took into consideration everything you asked for, but no, here are our findings.
Can I
Right,
add
and just because the LHRC, has their findings that are specific to the petition, a lot of times what I do as an advocate, if there are things that aren't included on the petition, but it was said during, presentation and I as an advocate want to follow up on it, I just kind of make a note to myself and I follow up on it separate from the petition.
Okay.
That's where I was
Thank
going
you.
with that. Because I think you bring up a really good point, Jen, that they may identify things that we just didn't see earlier, or somebody says something in the hearing and you're like, man, I didn't even know they were doing that. And as an advocate, we're always advocates. So if they identify something that doesn't rise to the level of a violation or even a recommendation, it is totally appropriate and fair game for you to then do your own separate review to follow up with the provider about something else that they identified, assuming it's pursuant to our regulations. It's also a good way of making sure that the process is pure, because it really is unfair to a provider to litigate something that they didn't have an opportunity to bring information about.
Right.
So if we were to travel down that rabbit hole of, oh, well, they didn't, they also gave her this and that, and it was just based on one statement, we really don't know if the provider has additional evidence or information about that. So it's appropriate for us to look into it, but it might not be appropriate to litigate or talk about it at that particular setting.
Right.
Gotcha. Great job. This was amazing. I agree with everybody. 100% enjoyable training. I learned stuff from it. So kudos to everybody.
Thank you. Other questions about the process or anything?
I'm just curious, and maybe it's because of the age, why wasn't the daughter involved? Because we kept on asking, has the daughter said this to you or not? So it's just, why wasn't the daughter involved with the hearing?
I think we were going to have somebody play my daughter, and she totally could have been. Like,
okay,
that happens. It's up to the individual if they want to participate.
Right, especially when it's a minor. This was a minor, so mom came in and represented. She was at school, Mary Claire.
Oh, yeah, right. Okay.
Oh, she was at school. Oh, okay.
I did want to talk about one more thing that kind of tags on to what Jen was asking about what to do when somebody, either party, brings up new evidence, right, that wasn't included in the petition, because that does happen. And so basically, let's say you're in the hearing and you've got exhibits A through E, but the provider says, hey, I also have F, but nobody had that, right? It wasn't part of your petition packet. The individual didn't see that, et cetera. What has to happen at that point is the provider has to request of the LHRC to enter that into evidence, basically as an exhibit. And the committee will consider that, and they will also consider if the individual has an objection to it. So ultimately, it's up to the LHRC to decide whether or not to allow that new evidence to come into play. So that is something that comes up. It's come up a few times with us. So I wanted to let you know that it's not out of the question that somebody might bring something new and that the LHRC says, yes, that would be helpful to us in making a decision today, one way or the other. So, and if let's say the individual does it and the provider objects, they can object and the LHRC can still say, that's okay. We note your objection and we're still going to take that evidence. So wanted to add that. Thanks for that reminder, Tia. Any questions about that or final thoughts from Tanika, Jennifer, Mary Claire, anybody? I would be curious to know how many people in the Zoom have actually been in a hearing or have never done a hearing. Do we have a bunch of people? It's hard to tell because I guess some people don't have videos.
Okay.
Yeah, but I was interested about that. So yeah, that's it. I think we're done a little bit early. It's a long training. That's how long the process takes. So thank you, guys.
Cassie, there's a few people in the chat that were saying they have not. Holly and Heather Oaks.
Gotcha. And I would say there are more too. So hopefully it takes the fear out of the hearing for everyone. And please let us know if, you want to tag into a hearing. We have them a lot over here. So if we have an extra advocate and we have permission to let you in, then we'll do that. That way you can see it in real time. All right.
I
give
wonder,
it
Carlton, if you wanted to say something about the handbook.
Oh, good idea.
Yep. Thank you, Region 1, Cassie and Artia. This was absolutely wonderful. It was amazing. So with that, there was an LHRC work group that convened, I think back in early August or late July. And the work product from that group was the development of an LHRC handbook. So I'm going to just show it to you briefly now. I'm not going to go through the whole thing because you all will have access to it. Give me 1 second. All right. So the handbook it's meant to be a resource, kind of a one-stop shop for all things related to the LHRC and SHRC processes. Again, a lot of what is in this handbook came from the resources that were put together by Region 1. And if it wasn't for those documents and the time and effort of Region 1, then this would have been a more painstaking endeavor to get through. So let me just show you the table of contents. And then once you all get it, you can go through each of these sections. But we really break down some definitions. We talk, of course, about FOIA. And then the major sections are going to be 4 and 5. Well, it really goes through the process of the LHRC, from your preparation as the advocate to the LHRC meeting, and then, of course, to the fact-finding hearing. And then we go through that again in the SHRC and appeal process. So what's included in this is all of these appendices. And if you go to the end of the document, and if you're looking at this online, there are a lot of hyperlinks. So as you see a note and as it references something that's in the appendix, you can just click it and it'll take you directly there. Of course, if you print it out, you'll just flip to it. As I'm getting to the appendices, the other thing that I want to point out is that if the process is related to a protocol, like you see here, and the reason you see the difference in these numbers is because there's a new protocol manual that's going to be coming out. So I tried to make this to match that. But as you go through the process in each section, then our internal protocol and process is going to be identified so that you can always have that to reference as well. But what I'm most excited about, so you'll see the FOIA presentation, you'll have all of the forms that we use. And then for consistency across the state, you'll see that there's an agenda template. So it's the expectation that this will be the agenda template that we're all using moving forward. You'll also see that there's a minutes template, which again is for consistency across the state. We also have a section in here about Robert's Rules of Order. So Robert's Rules of Order is a very extensive document because we do not, in the Office of Human Rights, follow all of Robert's rules. This document highlights those parts of Robert's rules that we do follow. So here you'll see how to call for motions, how to call for votes. You'll have your closed session script and what you need to say in order to return to open session in a meeting. This document is one that I found when I first started with the office, and I thought it was very helpful. It was more of a condensed version. It made it easy for me to understand. There are plenty of other documents out on the internet, so feel free to look for look for others that you may find helpful. But it talks about some of the different motions and how those motions are presented and how votes and things are called. So again, some very good information here for you. So again, this is specifically about when you're going in and out of closed session. I think I referenced that earlier. So this is the section that I'm most excited about. So it starts in Appendix G. And here is where all of the resources and all of the time and effort that Region 1 put into this really came in handy in presenting and developing this document. Now, some of these forms have been updated. So Region 1, if you're looking at it, it's the same information, it's just been updated. All of these forms have been made to be fillable as well. So you can type into these forms, or if you wish, you can print them out and you can write in them on a hard copy. But this is the hearing and review procedures checklist. Literally, when I saw this, my mind was blown. And I wished that the hearings that I participated in Region 5, I wish that we had something like this, because it literally takes you step by step from the moment that the individual says they want to appeal until the end of the whole appeal process. Follow this. If you follow this, do everything in order as it tells you to do, you will not have a problem getting through a hearing. I can guarantee you that. And if you do have a problem, then you can blame Cassie. No, don't blame Cassie. This is, y'all, again, this is probably the best resource within the Office of Human Rights, these documents here. So again, it's the full checklist, and it's long because it's the full checklist. These letter templates, all you have to do is pull it up, and I've made all of these fillable as well. So the only thing you have to do is type in the information that says type provider's name here, or choose a complaint case, or the date is even fillable. So it's very user friendly, and it gets you through the process with no headaches whatsoever. Everything that Artia and Cassie mentioned today is in this document. And I believe these forms are updated, but I'm going to get with Cassie and Artia to make sure that no other changes need to be made to any of these documents before it goes out to you all. So again, thank you to Cassie, to Artia, to Laquetta, to Richie. I think I covered everyone who was responsible for the development of these forms. So you all should be getting that very soon.
And Lena.
And Lena, yes, thank you. And to the work group, which included Artia, Mandy, and Latoya. That's all I have.
Thank you, Carlton. Jennifer, do you have anything before we finish up? I know Tanika had to go, and so I'll throw it
No,
in.
not at all. Thank you, everyone, for joining. It was a great training. Thanks, Cassie, and for everyone who had a role today. It was awesome.
Mary Claire, you have anything?
And thanks, Carlton. The book is just incredible.
Just to kind of piggyback on Jennifer, I mean, it was a great training. Y'all did a great job with this. So kudos to everybody that was involved. I'm excited now to go to an actual LHRC meeting soon. So I just think this was great. And Carlton and group and team, thank you for that LHRC information. I can't wait to read the whole thing because for somebody who doesn't do it all the time, so thank you very much. Now everybody gets to go and eat lunch because I know Carlton sounds like he's starting.
Since deliberations, hungry man. All right. Thanks, everybody. We'll go ahead and end the meeting now, and let us know if you need anything for your hearings.
I think real quick,
Bye.
Carlton, Jen and Glenn had a question where the handbook will be located. It's in the.
Carlton
There you
mentioned
go.
that.
He got it. He posted it in Teams.
It'll be posted in Teams.
All right. We'll leave the chat box open for just a minute before we close the meeting. Thanks, everybody.
I have a general question, if anybody knows. We saved some things on the shared drive and some things in Team. Is there, I don't know which is best now, if anybody has an idea.
Yeah, I can actually take that.
Okay.
It looks, we're going to be moving away from shared. Right now,
okay.
I'll say if something needs to be uploaded, it should be, you should get with your appropriate associate director and or Tanika, but more than likely it's going to be in Teams for right now until SharePoint it's straight, which those two are connected anyway. So.
Okay, that sounds good. I'm just so used to the shared drive. It's hard for me to break away, but this is good to know what we're using. So thank you.
Yeah. And the SharePoint, once you really get a hang of it, it really is, it's a lot better than shared drive, especially because it connects to Teams.
Mm-hmm. Okay. All right. Thanks, everyone.
Hey, Heather, look at your name. Oh, she left before she could see it. Thanks, everybody. Thanks, Carlton, for the Zoom link and for all your technical support with this.
Oh, you're welcome anytime. And again, really thank y'all. Like y'all are to be really commended for this. So
thank you. Talk to y'all later. Bye, Mary Claire.
All right. See you, Mary. Is Mary Claire frozen?
She's either frozen or she's playing freeze.
She doesn't want to talk to us.
Bye.
See y'all.